we are now on our chapter 5 of our main reference ebook by Corey and Kalahan entitled Issues and Ethics in the Helping Profession. And our chapter 5 is dealing on the client rights and counselor responsibilities. So let us go back again to the very definition of the informed consent. Informed consent is a process, a way of engaging the full participation of a client. It means it is empowering the client, giving it clinical as well as ethical significance, especially in the case of clients who've been victimized. Issues of power and control can be central in the therapy process. How do, how do practitioners assist clients in becoming informed partners? Some recommend that information about the therapeutic process be provided to clients both verbally and writing. So in here, we have to remember that when we give information of the therapeutic process not only by verbal, by words, but we have to put into writing. And that clients have the right to know what the therapy process entails because they are buying a service from a professional. Some of the topics they have developed include a series of questions pertaining what therapy is and how it works, the clinician's approach, alternatives, appointments, confidentiality, fees, procedures for filing for insurance reimbursement, and the policies pertaining to managed care. So let us also go back to another, let us also take another case, in the case of Kieran. Kieran is a counselor in a community agency setting who has strong religious beliefs. He is open about this in his professional disclosure statement, explaining that his religious beliefs play a major part in his personal and professional life. Carmel comes to Kieran for counseling regarding what she considers to be a disintegrating marriage. Kieran has strong conviction that the favor preserving the family unit. After going through an explanation of the informed consent document, Kieran asked Carmel if she's willing to join him in a prayer for successful outcome of therapy and for the preservation of the family. Kieran then takes a history and assures Carmel that everything can be worked out. He adds that he would like to include Carmel's husband in the sessions. Carmel leaves and does not return. In this case, do you see any potential ethical violations on Karen's part? Yes, at the very beginning there was, because of the religious belief and values of Karen, which is somehow imposed to Carmel. And this is the religious belief. If Karen came to you for consultation, what might you say to him? I might also express my feeling that, of course, I have this concern, and of course, I should also be given the opportunity to express my mind and to share of what I have, and not that automatically there is already what we call an imposition of religious beliefs and values that might have also stopped me from sharing. Is it appropriate to include your personal values and belief in the informed consent process? Do clients have a right to know your personal values? How might this help or hinder their work with you? It's so clear that ethical standard that counselor should not impose his values and belief, because of this might limit or lose the sense of openness, because there is already what we call a pre setting of one mindset if you impose your values, especially on religious values, and that will hinder a more healthy and better therapeutic relationship. And here we see that although we appreciate Karen's practice in presenting his values as part of the reform consent process, we question his approach to Caramel. He does not assess the client's state of mind, her religious convictions of any, the strength of her convictions, and her degree of comfort with his approach. Caramel may have felt pressured to agree with him in this first session, and she may have had the strength to disagree openly. We question whether Carmel is able to give truly informed consent under these circumstances. It's not appropriate for the therapist to introduce prayer into the sessions, even though he tells clients that this is a part of his philosophy. If this is important to Carmel, it would be her place to introduce prayer in the session. So, um, getting across with this kind of example, you could just imagine that even your religious belief, because somehow, of course, it may not be helping because others may have different views on belief and religion. So keep in mind that providing clear, informed consent about one's convictions does not relieve counselors of the duty to respect clients' cultural traditions, including religious beliefs and the prohibition regarding imposing one's values on clients. So let's go back to the content of informed consent. One of the main aims at the first meeting is to establish rapport and create a climate of safety in the therapeutic situation. Realizing that informed consent is an ongoing process, the challenge is to provide clients with just right amount of information at this session for them to make informed choices. The types and amounts of information, the specific content of informed consent, the style of presenting information, and the timing of introducing this information must be considered within the context of the state licensure requirements, work setting, agency policies, and the nature of the client's concerns. The content of informed consent is also determined by the specific client being served. It should be added that there is no assurance that practitioners can avoid legal action even if they do obtain written informed consent. Rather, focusing on legalistic documents, we suggest that you develop informed consent procedures that stress client understanding and foster client counselor dialogue within the therapeutic partnership. Now let's go to the therapeutic process. Although it may be difficult to give clients a detailed description of what occurs in therapy, some general ideas can be explored. We support the practice of letting clients know that counseling might open up levels of awareness that could cause pain and anxiety. Clients who require long-term therapy need to know that they may experience changes that could produce disruptions and turmoil in their lives. Some clients may choose to settle for a limited knowledge of themselves rather than risking this kind of disruption, and this should be explored but also respected. We believe it appropriate to use the initial sessions for a frank discussion on how change happens. Clients should understand the procedures and goals of therapy and know that they have the right to refuse to participate in certain therapeutic techniques. So you could just see that they should be informed and they have also the right to refuse to participate in certain therapeutic techniques because of the very fact that there will be disruptions that would even change, uh, cause pain in society, or there will be also what we call changes, okay, that will happen. Let us now go to the background of the therapist. The therapist can provide clients with the description of their training and education, their credentials, licenses, and any specialized skills, their theoretical orientation, the types of clients and types of problems in which they have competence, and the types of problems that they cannot work with effectively. And this is important for the therapist to at least he will know his limits and also his competence. State licensure boards often make giving this information a legal requirement. So the background of the therapist is very important because of the legal requirement. If the counseling will be done by an intern or paraprofessional, clients should be made aware of this. Likewise, if the provider will be working with a supervisor, this fact should be made known to the client. This description of the practitioner's qualifications, coupled with a willingness to answer any questions clients have about the process, reduces the unrealistic expectations clients may have about therapy. It also reduces the chances of malpractice actions. When you disclose your values, clients are in a better position to decide whether to work with you or not. So it's so important that the therapist should also disclose to his clients his values, uh, because this will also it will help to for the clients to decide if he's going to work with you or not. However, this disclosure should be based on the client's needs and situation. By disclosing values, that would make it difficult for you to maintain objectivity. The client is protected by the effects of your bias. If you fail to make such disclosures and later refer your client to due to value conflicts, you may face legal jeopardy related to bonding your client. So the timing of disclosure also is important as too much information at the beginning of the therapy. Extraneous information may also serve to confuse or overwhelm the client. So again, um, disclosure and disclosure of our values of to our client will also help actually whether they are going to work with us for the therapeutic sessions. Now let's go to the cost involved in therapy. Uh, we may be asking how much does it cost in the therapy. It is essential to provide information about all costs involved in psychological services at the beginning of these services, including methods of payment. Clients need to be informed about how insurance reimbursement will be taken care of and any limitations of their health plan with respect to fees. If fees are subject to change, this should be made clear in the beginning. So even how much it going to cost the therapy in the very beginning they have to. Okay. Let us also go to the length of therapy and termination. So this is also important. How long it will take the therapeutic process and how long it's going to terminate. So the length of therapy and terminations. Clients should know that they can choose to terminate therapy at any time. Yet it is important for the client to discuss the matter of a termination with the therapist. Part of the informed consent process involves providing clients with information about the length of treatment and termination of treatment. Regardless of the length of treatment, it's important for clients to prepare for a termination phase. Termination should be addressed from the outset of the professional relationship. An effective termination process is critical in securing trust in the overall therapy process while minimizing the return of symptoms or feelings of exploitation. Termination is a key phase of everyone's client's treatment, and therapists should help clients plan for it, prepare for it, and process it. Okay, termination is a key phase of every client's treatment, and therapists should be help clients plan for it, prepare for it, and process it. Let's also go to the consultation with colleagues. Student counselors generally meet regularly with their supervisors and fellow students to discuss their progress and any problems they encounter in their work. It's good policy for counselors to inform their clients that they may consult with other professionals on their cases. Experienced clinicians often schedule consultation meetings with their peers to focus on how they are serving clients. Even though it's ethical for clinicians to discuss their cases with other professionals, it is wise to routinely let clients know about this. Clients will then have less reason to feel that the trust they're putting in their counselor is being violated. So, which means when this is consultation with colleagues, it is also part that the clients should also be informed that that there will be consultation with other colleagues so that they are informed and not to destroy, to break the trust and confidentiality. Okay, let's go to interruptions in therapy. Okay, most ethics codes specify therapists should consider the welfare of their clients when necessary to interrupt or to terminate the therapy process. Okay, it's good practice to explain early in the course of treatment which clients the possibilities for both expected and expected interruptions in therapy and how they might be handled. A therapist's absence might appear as abandonment to some clients, and especially if the absence is poorly handled. So it's possible therapists should have a plan for an interruption therapy, such as vacations or long-term absences. When the practitioners plan vacations, ethical practice entails providing clients with another therapist in case of need. So clients need information about therapist's method of handling emergencies, part of the rotation to treatment. Okay. Now we go to the benefit and risk of treatment. So what are the benefits and risks of treatment? Clients should have some information about both the benefits and the risks associated with the treatment program. Due to the fact that clients are largely responsible for the outcomes of therapy, it's good policy to emphasize the role of the client's responsibility. Clients need to know that no promises can be made about specific outcomes, which means that ethical practitioners avoid promising a cure. When therapists use techniques that are not traditionally recognized, they are expected to inform the clients of the potential risks and alternatives to such treatments. So, which means clients should know that no promises can be made about specific outcomes, which means that ethical practitioners avoid promising a cure. Now let's go to alternatives to traditional therapy. According to ethics codes of some professional organizations, clients need to know about alternative helping systems. Therefore, it's good practice for therapists to learn about community resources so that they can present these alternatives to a client. Some alternatives to psychotherapy include self-help programs, stress management programs for personal effectiveness training, peer self-help groups, indigenous healing practices, bibliotherapy, 12-step programs, support programs, and crisis intervention centers. This information about therapy, its alternative, can be presented in writing through an audio tape or video tape or during an intake session. An open discussion of therapy and its alternatives may, of course, lead some clients to choose sources of help other than therapy. For practitioners who make a living providing therapy services, asking their clients to consider alternative treatments can produce financial anxiety. However, openly discussing therapy and its alternatives is likely to reinforce many clients' decisions to continue therapy. Okay? Clients have a right to know about alternative therapeutic modalities that are known to be effective with particular clients and conditions. Okay? Now we go to the tape recording or video recording sessions, um, which means that clients have a right to be informed about this particular procedure at the initial session, and it's important that they understand what they are recording or why the recordings are made, how they will be used, who will have access to them, and how they will be stored. Therapists sometimes make recordings because they can benefit from listening to them or by having colleagues listen to their interactions with clients and give them feedback. It's essential for trainees or counselors to secure the permission of clients before making any kind of electronic recording. So that is very important. Now we go to the client's right access to their files. Clinical records are kept for the benefit of clients. Rimley and Hurley maintain that clients have a legal right to inspect and obtain copies of records kept on their behalf by professionals. So clients have the ultimate responsibility for decisions about their own healthcare. In most circumstances, also have the right of access to complete information with respect to the condition and the care provided. A professional writes about a client in descriptive and non-judgmental ways. A clinician who operates in a professional manner should not have to worry if his her notes were to become public information or be read by client. Let us now go to the last point for the informed consent is this, the nature and purpose of confidentiality. Clients should be educated regarding matters pertaining to confidentiality, privileged communication, and privacy, which will discussed in the chapter 6. Of all the professional codes have a clause stating that clients have right to know about any limitations of confidentiality from the outset, the very beginning. For example, the Code of Ethics of the American Mental Health Counselors Association in 2000 has the following principle pertaining to confidentiality. At the outset of any counseling relationship, mental health counselors make their clients aware of their rights to confidential nature of the counseling relationship. They fully disclose the limits of or exemptions to confidentiality and or the existence of privileged communication, if any. So at the outset, the client should be aware of his rights regarding the confidential nature of the counseling relationship. Putting this principle into action not only educates clients but also promotes trust. I think it's so clear that when there is what we call at the very beginning, the client is informed and it creates a kind of trust. The effectiveness of the client therapist relationship is built on a foundation of trust. If trust is lacking, it's unlikely that clients will engage in significant self-disclosure and self-exploration. Unlikely the clients will engage in. Part of establishing trust involves making clients aware of how certain information will be used, whether it will be given to third-party payers. Let's go now to the professional's responsibilities in record keeping. From ethical, legal, and clinical perspective, an important responsibility of mental health practitioners is to keep adequate records on their clients. The standard of care for all mental health professionals requires um, keeping current records for all professional contacts. Record keeping serves multiple purposes. The primary purpose for keeping records is to provide high quality service for clients and to maintain continuity of service if other professionals are involved. Good record keeping also documents that adequate care was provided, which could be an issue in a disciplinary hearing. So we have to look at this record keeping in different perspectives. First, from a clinical perspective, record keeping provides a history that a therapist can use in reviewing the course of treatment. And that's clinical perspective. For ethical perspective, records can assist practitioners in providing quality care to their clients. And that's ethical. From a legal perspective, state or federal law may require keeping a record, and many practitioners believe that accurate and detailed clinical records can provide an excellent defense against malpractice claims. From a risk management perspective, keeping adequate records is the standard of care. Okay, keeping adequate records is the standard of care. So let's now distinguish between progress notes and process notes. Progress notes are a means of documenting aspects of client's treatment and are kept in a client's clinical record. These notes may be used to document significant issues, concerns, or revealed to a client's treatment. Then progress notes are behavioral in nature and address what people say and do. They contain information on diagnosis, functional status, symptoms, treatment plan, consequences, alternative treatments, and client progress. And the other one, process notes, or psychotherapy notes, are not synonymous with progress notes. Process notes deal with client reactions such as transference and the therapist's subjective impressions of a client. Other areas that might be included in the process notes are intimate details about the client, details of dreams or fantasies, sensitive information about client's personal life, and a therapist's own thoughts, feelings, and reactions to clients. Process notes are not meant to be readily or easily shared with others. Okay? They are intended for the use of the practitioners who created them. As a general rule, it is best to exclude from process notes pertaining to diagnosis, treatment plan, symptoms, prognosis, and progress. The law requires to keep a clinical record of progress notes for all clients, but the law does not require keeping process psychotherapy notes. Okay, remember. So the law requires the progress notes, the clinical record, but the process notes or psychotherapy notes, the law does not require keeping process because this must be need kinds of confidentiality. The IHPAA privacy rule allows clinicians to keep two sets of records but does not mandate it. The idea of two sets of records is that one set of progress notes is more general, less private, more readily accessible to insurers and clients. The other set of process notes is more private and for the use of the therapist. If a therapist does keep process notes, they must be kept separately from the individual's clinical role. Legal requests for documentation in the context of litigation may include requests for process notes as well as progress notes. So it's prudent to consider the process notes may also be suddenly become a subject of courtroom scrutiny. A client's clinical record is not the place for therapists' personal opinions or personal reactions to the client. A record keeping should reflect professionalism. Okay, a record keeping should reflect professionalism. If a client misses a session, it's a good practice to document the reasons. In writing progress notes, use clear behavioral language. Focus on describing specific and concrete behavior and avoid jargon. It may help to assume that the contents of this record might someday be read in a courtroom with the client present. Although professional documentation is expected to be thorough, it is best to keep notes as concise as possible. Be mindful of the dictum. If you did not document it, then it did not happen. So if you did not document it, then it did not happen. So let us now take the case of Noah. Noah is a therapist in a private practice who primarily sees relatively well-functioning clients. He considers keeping records to be basically irrelevant to the therapeutic process for his clients. As he puts it, in all that a client says to me in 1 hour, what do I write down and for what purpose? If I were seeing high-risk clients, then I certainly would keep notes. Or if I were a psychoanalyst where everything a client said matters, then I would keep notes. One of his clients, Sue, assumed that he kept notes, and one day after a session asked to see her file. Noah had explained his lack of record keeping to Sue. Okay. So what do you think of Noah's attitude to record keeping? So Noah thought about the less importance of keeping note keeping. Okay, so it's unethical because exactly when Zhu asked for the file, then he has nothing to give because of he does not put into writing. So what do you think of taking into consideration the kind of clientele Noah sees? It is behavior justified? If you disagree, what? Okay. Yeah, it is a kind of it is a progress notes. Okay, progress notes because Sue would like also to to have record of the previous sessions. What if a legal issue arises during after Sue's treatment? How would documenting its session help or not help both client and counselor? Assuming that some of those clients will move to other locales and seen the therapist, does the absence of notes be transferred to the nurse have ethical implications? Yes. There must be a sense of continuity of the professional help. There must be a sense of continuity. How do you react to Noah's opinion that keeping notes relevant in this practice? Explain. Perhaps Noah would like to tell that because of he might be thinking also of uh, a kind of relational or treatment or approach to Zoo as her as his client. But then you could just see that there is an ethical implications there. Okay. How do you react to Noah's opinion of keeping this? If keeping notes were not mandated, would you still keep notes? Where I think it's so basic because our memory cannot actually contain, and the retention of our memory is not that we could just say that we have retentive memory. So we have to jot down notes. Note taking. Okay. So keeping adequate clinical records is a legal and ethical requirement regardless of the degree of function of a client. So it is legal and ethical requirement regardless of the degree of functioning of a client. Note taking is a critical component of therapy. It can help the therapist remember relevant information. It's useful as a review of clinical procedures used with the client. Few therapists, if any, can remember everything that is covered in a given session over the course of time. No one may have to justify in the courtroom how his decision not to keep clinical records affected the standard of care of his clients. Bennett and colleagues, 2006, reminds us that legal requirement for maintaining clinical records involves much more than following a certain arbitrary rules. Good documentation demonstrates that you use a reasonable standard of care in conceptualizing, planning, and implementing treatment. Okay. So let's also go to the legal perspective of record keeping. And again, according to Rivas Vasquez and his colleagues, 2001, the adage, if it is not documented, it did not happen, has never been more relevant than today's climate of heightened awareness of potential liability exposure. Okay, let us also take an example of this case notes. And case notes is that it should not be altered or tampered with after they have been entered into the client's record. Tampering with the clinical record after the fact can cast a shadow on the therapist's integrity in court. Enter notes into client's record as soon as possible after therapy session and sign and date the entry. Okay, if you are keeping client notes in a computer, it's essential that your program has a time and date stamp so that if your records are subframed, there will be no question of altering material at a later date. The content and style of clients' records are often determined by agency or institutional policy, state council or licensing laws, or directives from other regulatory bodies. The particular setting and the therapist's preference may determine how detailed the records will be. The American Psychological Association 2007 lists the following content areas for inclusion record keeping. So this must the content of the record keeping, identifying data, fees and billing information, documentation of informed consent, documentation of waivers, confidentiality, presenting complaint and diagnosis, plan for services, client reactions to professional interventions, current risk factors pertaining to danger to self or others, plans for future interventions, assessment or summary information, consultations with or reference to other professionals, relevant cultural and social political factors. Okay. Now we go to the record keeping guidelines. Also document procedures for practitioners working with multiple individual and couples, family, and group therapy. When therapists work with multiple clients, the issues involved in record keeping can become complex. Disclosure of information on one client may compromise the confidentiality of other clients. It may be useful to maintain separate record for each person participating in group therapy. When counseling couple or family, identified client may be the system in which care practitioner might keep a single record for the couple or the family. Okay, now record keeping for managed care programs, and this is practitioners working within managed care setting are required to maintain adequate documentation of treatment services. Typically, such organizations require documentation for payment to be received. A managed care program may audit practitioners' reports at any time by law. On 78 Chapter 5, managed care practitioners are required to keep accurate charts and notes, and must provide this information to authorized charge receivers, reviewers. Case law, licensure board statutes, and rules, and Medicare and Medicaid reimbursement regulations all contribute to finding minimum information that mental health records must contain the managed care context. This information includes the following: client identifying information, client's chief complaints, including pertinent history, objective findings from the most recent physical examination, intake sheet, documentation, or referrals to other provide when appropriate, findings from consultations, and the referrals to other healthcare workers, pertinent workers, or diagnostic procedures, tests, signed informed consent for data. Okay, now we go to record keeping for school counselors. In some counseling settings, it may be difficult to keep up with record keeping. For example, school counseling a student to counselor ratio of 400 to 1. It's not uncommon. So this is, I think, let us deal with this more, because of, I think this is where we can actually relate with, because of most of us are working with school setting, the record keeping for school counselors. Now let us go back to the record keeping for school counselors. We might ask the question, how realistic is to expect a school counselor to keep detailed notes on every contact with a student? Birch Hall and Hoover 2000 indicate that a well-kept record may be useful to demonstrate that the quality of counseling provided was in line with acceptable standard of care. Keeping records is particularly important in cases involving moderate to severe social or emotional problems, or when students may be at risk of suicide. Maintaining records on parent contacts is also essential. School counselors are cautioned about the importance of safeguarding the confidentiality of any records they keep. Okay, the ethical standards for school counselors, or ASCA, American School Counselors Association, addresses the issue of record keeping on students. The professional school counselor must have the following: maintains, secures records necessary for rendering professional services to the students required by laws, regulations, and institutional procedures and confidentiality guidelines. Okay, second, keeps sole possession of records separate from students' educational records in keeping with state laws. The skilled counselors need to be concerned about both administrative and clinical records. Administrative records are the cumulative files on students that are available to other school personnel. Clinical records are the case notes documenting important events regarding counseling relationship with a student. At times, school counselors may need to educate teachers about what to enter into a student cumulative folder. One of the colleagues reports that he had to ask teachers to rewrite their observational reports to remove judgmental terms such as lazy or bully. Okay? So school records are open for parents to review. It is essential to refrain from making negative comments concerning parents in administrative records. These records also file students to other schools and can provide biased opinions. All school staff and counselors need to stick to the facts and limit their personal judgment. Okay? And school counselors need to understand the provision of the Family Educational Rights and Privacy Act of 1974. This federal law requires that school receiving federal funds provide, again, this is based in America, so we're trying to, okay, it says that student records are not to be released to third parties without the written consent of parents of minors or the written consent of adult students. Okay, now securing records now in the future. Clients' records must be handled confidentiality. Clients' records must be handled confidentiality. Code of Ethics of AZA 2005 provides guidelines for storing, transferring, sharing, disposing of clinical records. Okay, so guidelines for storing, transferring, sharing, and disposing clinical records. Counselors have responsibility for storing client records in a secure place and exercising care when sending records to others by mail or through electronic means. Be aware that the information in the client's records belongs to the client and a copy may be requested at any time. It is mandatory to treat a client in an honest and respectful fashion. It's also expected that accurate records will be kept. So, mental health practitioners bear the ultimate responsibility for what they write, how they store and access records, what they do with these records, and when and how they destroy them. So, clinicians are ethically and legally required to keep records in secure manner to protect client confidentiality. They are also responsible for making responsible steps to establish and maintain the confidentiality of information based on their own delivery of services and services provided by others working under their supervision. And also in this clinical record or case notes, lastly, it says here that okay, if it is wise to think that what will happen to your clinical records after your death if you are otherwise incapacitated, in case the counselor or therapist, counselor also already died or incapacitated. Most state laws do not specify how records are to be handled upon therapist's death, but according to Remersma of 2000, suggests that you give thought to how you expect your records to be handled before it is too late for you to be involved in decision making. Consider creating a professional will that names other professionals who, at least temporarily, will handle your files and clients if you died or become otherwise incapacitated. Okay, so which means you have to already endorse ahead, okay, to another counselor or professional. Okay, and here are some questions to consider. Who will have access to your records in the event of your death? Should you clients be given the opportunity to obtain the records, or should they be given the opportunity to have the records transferred to another therapist, or should the records be placed in the custody of another health care professional with the clients so notified? Should the records be destroyed immediately with or without giving clients the opportunity to retrieve the records? And is a therapist in the community willing to take over your practice in the case of your death? And I think these are important to answer these questions to safeguard your estate. A client can bring suit against your estate after your death if you have failed to consider some of these matters. Even death does not shield us from a malpractice suit. Even death does not shield us from malpractice suit. And that's the last part of my report. And if you can check the link of our report of the informed consent and professional responsibilities in record keeping, and you can check on the link chapter 5 by Corey and Colahan in this topic that we have. So thank you very much for listening, and hope that you learned something from our report of the informed consent and professional responsibilities in record keeping. Okay. Thank you and stay safe.